Shop 4th of July savings at the Home Depot right now and get up to 40% off, plus up to an extra $600 off select appliances with free delivery, like Samsung. From all-in-one washer dryers to smart refrigerators, upgrade to tech you can trust with Samsung appliances. The Home Depot has what you need to simplify your routine. Don't miss 4th of July appliance savings at the Home Depot. Free delivery on appliance purchases of $396 or more. Offer valid June 18th through July 9th. U.S. only. See store or online for details.
Today on CityCast Madison. The Wisconsin Supreme Court dropped a historic decision right before the 4th of July weekend. The court, in a 4-3 split along ideological lines, struck down the now infamous 1849 abortion ban. As context, the now invalidated law has been at the center of years of litigation and a leading issue in Wisconsin's past 2 state Supreme Court elections. To better understand the court's ruling and potential impacts, we sat down with a local legal expert and Planned Parenthood of Wisconsin strategic consultant, Nicole Safar. It's Monday, July 7th. I'm Bianca Martin, and here's what Madison's talking about. Nicole, thank you so much for coming on CityCast Madison.
Bianca, it is really just my pleasure to be here with you.
Yeah, so we're talking to you in the immediate aftermath of the court laying down a historic, highly anticipated decision on Wisconsin's 1849 abortion ban law. The news, the court struck it down. We want to help folks make sense of what happened. So briefly, the lawsuit that they just ruled on was a challenge to enforcing the ban brought forward by Democratic State Attorney General Josh Kaul just about 3 years ago, immediately after the U.S. Supreme Court overturned Roe v. Wade. Attorney General Kaul said this at a press conference Wednesday.
We have, in fact, now succeeded in protecting access to safe and legal abortion in Wisconsin and providing the clarity that we sought through this case.
Nicole, there's a lot of context to this decision, to this moment. What was the specific case the court just decided on?
Yeah, so I first just want to start with the fact that today's decision from the court really is a victory for patients, doctors, and for basic human dignity in our state. Abortion is and remains available in Wisconsin. So your listeners really should understand and know that abortion is available in our state. There has been so much chaos and confusion in the wake of the Dobbs decision a couple of years ago. And every day, we hear from people who are unclear about that fact. And this case, again, really once and for all says that 1849 law is not in effect. But there is a lot of context to it. I think over the last few years, especially since the federal U.S. Supreme Court overturned Roe v. Wade, people have really come to learn about this law from 1849 that was passed in Wisconsin and had been in effect until Roe v. Wade in 1973, where abortion was illegal. And it just created a lot of confusion as the sort of pendulum kept swinging back and forth in the federal law.
100%. And so, as you established, the court has now made it clear that abortion is legal in our state. And I want to dig further into the case that was decided on because there are so many moving pieces. And I want to give a timeline too. What was the specific case that the court just decided on?
So, as many of your listeners, I'm sure know, Wisconsin has had a law on the books since 1849. That law banning abortion was in place for much of the state's early history until the United States Supreme Court granted constitutional rights and protection for abortion access in Roe v. Wade. So when Roe became the law of the land, then that Wisconsin criminal law was basically stayed and it could not be enforced. So in Wisconsin, we had many years of abortion being legal because of Roe v. Wade, and the state legislature going in and regulating access to abortion. So, in the almost 40 years between Roe v. Wade and the Dobbs decision, which overruled Roe v. Wade, the state of Wisconsin passed dozens and dozens of laws regulating who can perform abortions? What are the rules around abortions? How can people pay for their abortions? And really created this statutory regulatory scheme around abortion. So that's what happens for about 40 years. And then when the federal protections go away in the U.S. Supreme Court decision of Dobbs, we're stuck here in Wisconsin where we have this whole regulatory scheme that says how, if, and when you can get an abortion, and a law that says, oh, by the way, abortion is illegal. So what Attorney General Call did was he went to the courts and said, hey, we have these two points of view in the law that conflict with each other. We have abortion is illegal, and then we have all of these rules regulating abortion access. So how do people know which law should be enforced? And that was the initial question. After this case was filed, there were several physicians who intervened in the case to say, yeah, we also really need to know, is abortion legal or not? Because our ability to provide care for patients, our license to practice medicine are all at risk in this state if no one knows what the law is. So that's the question that ultimately got decided by the Wisconsin Supreme Court today. And what they said was, we agree with the Attorney General, we agree with these physicians who need to know what the law is, and that it is clear to us that Wisconsin law is that abortion is legal in our state because of the 40 years of the state legislature actually passing new laws to regulate abortion.
Mm-hmm. I want to clarify a question. I know many folks probably have. When abortion access in Wisconsin was reinstated, it was around the definitions of abortion and of feticide. That's the language that was being used. That didn't seem to play a role at the Supreme Court level, though. So what happened there?
So Attorney General Call initially brought this case in Dane County Circuit Court. So he went to the Dane County Circuit Court and said, hey, we need a judge to tell us which law controls. And Judge Schlipper heard arguments in the case that during those arguments is when the physicians chimed in and said, hey, we want to know what's going on here too. And it was Judge Schlipper then when she issued her decision was not necessarily what the Attorney General was arguing. This law has been repealed because of all of the modern attempts to regulate it. She used a different legal framework.
Got it. I think that's what has maybe made this a little confusing for people who have been trying to follow.
It is really confusing because, the Attorney General and the doctors made a bunch of arguments to the court about why the law should be thrown out. And the judge did her research and decided on a different reason about why to throw it out. So I think, then it goes up to the Wisconsin Supreme Court, and they also agreed that we needed to throw this law out, but they used the same legal reasoning that the Attorney General and the physicians had used.
Got it. This is becoming much more clear. The timeline is important for sure.
Yeah, I mean, litigation around these fundamental freedoms, which take into account decades of state law, decades of federal constitutional law, the potential for Wisconsin constitutional law, are really complicated. And there is not always an easy black or white answer, which, makes it challenging sometimes to just tell a clear story about it, because there are a lot of different pieces moving and there are a lot of different legal arguments that could be made.
Yeah, I feel much more expert having tried to prepare just for this interview and trying to, follow it these past couple of years. And as you pointed out, the ban was put in place a year after Wisconsin became a state. So there truly is so much precedent, so much to take into account. I do want to talk about this decision because it was a split decision, right? So there were dissenters. It was 4-3, and Supreme Court Justice Rebecca Bradley, who's a member of the court's conservative minority, said in a response, as a dissenter, that she felt this was a political decision from the majority, that the majority, quote, erases a law it does not like, making 4 lawyers sitting on the state's highest court more powerful than the people's representatives in the legislature. So frustration or ire about them getting rid of a law, I guess, in a way. Like, this is no longer feasible. How would you describe the broader dissenting opinion on this case? Does it fall into that category of Bradley's comments?
You know, Justice Rebecca Bradley's comments are really, and often as I think some of the quote unquote originalist justices do, is really cherry picking the history that supports her position, that supports her ideological position. She's talking about the will of the people and the people's representatives about a law that was passed in 1849 when over half the people in the state of Wisconsin did not have the right to vote. And that is the will of the people from today. How about we think about the will of the people in our current and contemporary times? And while we have not had the ability to vote on whether or not abortion is accessible in Wisconsin, because we don't have direct democracy here in our state, so we cannot put up the issue on the ballot like they can in many, many other states, we do have decades of public opinion polling that shows 70, 75, 80% of people in our state think abortion should be legal. And that is the will of the people. So if Justice Bradley was being transparent, that is where we are today. It is not 1849 anymore.
On July 19th, experience a night of wonderful music under the stars. Join Madison Opera for Opera in the Park, a free concert in beautiful Garner Park. A Madison summer tradition, Opera in the Park draws thousands of people to enjoy a concert of excerpts from opera and Broadway. Opera in the Park 2025 takes place at 8 p.m. on Saturday, July 19th. The rain date is Sunday, July 20th. The concert features music by Mozart, Bizet, Puccini, Beethoven, and more, performed by Renee Richardson, Emily Tragle, Andrew Bidlack, Benjamin Taylor, the Madison Opera Chorus, and the Madison Symphony Orchestra, conducted by John DeMaine. The audience is always invited to conduct with their light sticks on a special number. So pack your picnic, gather your friends, and join Madison Opera in Garner Park on July 19th to celebrate the power of connection through music. Learn more at madisonopera.org.
This podcast is brought to you by Carvana. Buying a car shouldn't eat up your week. That's why Carvana made it convenient. Car buying that fits around your life, not the other way around. You can get pre-qualified for an auto loan in just a couple of minutes and browse thousands of quality car options, all within your terms, all online, all on your schedule. Turn car buying into a few clicks and not a full week's endeavor. Finance and buy your car at your convenience on Carvana. Financing subject to credit approval. Additional terms and conditions may apply.
Can you talk about the big picture? What is the significance of this decision and outcome from the court?
Yeah, I mean, this was really a very straightforward and legal decision that a law that was passed decades and decades ago does not apply anymore because newer legislators have passed laws that regulate our modern time. So it could not be any straightforward when it comes to the law. There was no broad statements about reproductive freedom, or there certainly was not any political statement in this very basic statutory analysis. So that's kind of where we are today. And it, like I said, it is a huge victory that we have clarity around this, that physicians and health systems across our state can feel confident in their ability to provide abortion care without the threat of criminal liability. And that's a huge win. But this is not where we need to be right now in the state of Wisconsin. We have a real opportunity to protect access and expand access to abortion so it is aligned with what people in our state are demanding. And, during everything we see at the federal level, from the overturning of Roe v. Wade to the last, 6 months under President Trump's administration, where there's just been a constant attack on Planned Parenthood, on access to reproductive health care, we really need state leaders to step in and provide protection to the fundamental rights of the people who live in their state. So this is one step, but there is still so much more work to do to ensure that Wisconsin has constitutional protection for abortion and bodily autonomy. And also, our legislators are working on a bill that would put protection for bodily autonomy and abortion into our state statutes, which is another critical next step that's happening.
And I think a big thing that stands out is the clarity. In Wisconsin for 15 months, abortions ceased after Roe v. Wade. And I think there was a lot that was learned in that time about just how important having clarity is in this situation. So elective abortions remain legal in Wisconsin up to 20 weeks of pregnancy. That is clear.
Yeah, I think those 15 months where there was not abortion access in our state was really a dark time for reproductive health care. And the patients who had to navigate the system, whether, they were trying to go to Minnesota or Illinois to get the care that they needed, whether they had a pregnancy where they ended up in a hospital emergency room because of a health risk. These were very scary times. And having this clarity and knowing that women will have access to this healthcare is critically important.
And Planned Parenthood of Wisconsin also had a major case before the court. They were asking the state Supreme Court to rule the ban unconstitutional in a separate challenge. But on Wednesday, the court dismissed that case. So do you know why did they do that?
Well, the order that the court issued just said that the case was unnecessary because the Planned Parenthood case was challenging the 1849 ban and saying that it violated the Wisconsin Constitution. And the court said, well, we just threw that law out. So basically, you don't have a case anymore because that law is not enforceable. So you can't say that it's unconstitutional. And that's it. They didn't provide any other analysis or information. So, I think that what that means is that there need to be other legal strategies. Our state constitution has very clear language in it about everyone's fundamental and inherent rights, men and women, the inherent rights that we have. And the job of our court system is to tell the people what the laws of the state mean, right? The legislature passes laws and the court explains what they mean in cases where there isn't clarity. So what we really need is a court to basically put those rights into action for people. The constitutional right is clearly there, but I can't, as an individual person be like, oh, the Constitution protects my rights. We need that bit of legal analysis that says the Wisconsin Constitution protects bodily autonomy under the Individual Rights Clause.
We recently interviewed the CEO of Planned Parenthood Wisconsin and a Madison Planned Parenthood Health Center manager on some issues facing reproductive care access in the state. And we're going to drop a link to that conversation in our show notes if anyone wants to listen back. I know the fate of access to Planned Parenthood services and reproductive services across the country is in limbo. Nicole, before we let you go, what does the future of abortion access in Wisconsin look like? What are you paying attention to moving forward?
Yeah, I think this question just really makes the point about why we need constitutional protection in our state, because there is so much uncertainty. We used to have these robust federal protections that are gone. And as we have this multi-pronged fight against access to reproductive health care, against access to abortion that is coming out of Washington, D.C. through the Trump budget bill that passed the Senate, and maybe by the time this comes out, will have passed the House, that is really trying to take away the preventative care that Planned Parenthood health centers provide and is essentially a backdoor national abortion ban. There's just uncertainty. We don't know what it could look like in 6 months or a year. So all of the work that, we're doing both on the litigation side and in the legal space is really complemented by the organizing and the efforts of everyone to speak out and tell their elected officials, whether it's your state of Wisconsin elected officials who can support the Reproductive Freedom Act so we can get some protections in our statutes in Wisconsin, or if it is our congressional members so they can vote no on the federal defund bill. All of this has to work together so we can protect access to healthcare for the long term. But it is not nearly over, and maintaining access is not enough. We must protect that access when we have it and expand it when we can.
Well, Nicole, we really appreciate you making the time to come on and provide your legal analysis. You know, we're talking on the day of the decision coming down, and so there are lots of questions, and you've offered some clarity that is much appreciated. Thank you for taking the time on what we imagine is a pretty busy day for you.
Thank you so much. I am just a big fan of the show, and I am so happy to be able to talk with you guys.
That's Nicole Safar, local legal expert and strategic consultant for Planned Parenthood of Wisconsin. That's all for today, here on CityCast Madison. I'm Bianca Martin, your host. If you enjoyed the show, why not share this episode with someone who cares about our laws and liberties? All right, we'll be back tomorrow morning with more stories from around the city. Until then, take good care and take care of each other.